Tao Falilelo Jr. and Lex Logistics, case number 2020-00460.
Good afternoon, Your Honor. John Butler, P33908 on behalf of the plaintiff.
This is Alexandru Leahu for Lex Logistics.
Okay, all right. So today's date and time set for a hearing. The plaintiff is wishing to, or requesting of the court to grant a default judgment against Lex Logistics. Is that correct, Mr. Butler?
It is, Your Honor.
All right. Do you understand what's going on today, Mr. Leahy?
From the very first words, you can sense this case is about to spiral. On one side, we have Tao Fellow Jr., a small business owner, and on the other, Lex Logistics, a company facing a $25,000 claim. Now, this isn't just about money. It's about responsibility, accountability, and how quickly ignoring legal mail can turn into a financial nightmare. Here's the kicker. The defendant walks in looking completely unprepared, almost confused about why he's even here. And that's mistake number one. In court, confusion doesn't win cases. This hearing quickly evolves from a simple wage garnishment issue into a high-stakes battle where ignorance could cost a company tens of thousands. Stick with me, because what you're about to see is a masterclass in how not to handle a legal dispute, and the judge isn't about to let anyone off.
I don't have to be garnished for nobody. I don't see how did I receive all kind of whatever stupid stuff what the person who used to work for me, I don't know, apply and all that. To be honest, I'm not familiar at all.
So, Mr. Leahy, the way this works is if you have an employee, okay, who has a court case against them and they owe money, the person who is owed the money, they can get a part of their wages, and you would have to participate in that. And that's why Mr. Butler and his client is looking for that information to see if monies that Tao Falelo, monies that this person earned, that Mr. Butler's client has a right to a portion of it, that they're able to successfully get those monies. And so you're saying right now this person does not work for you?
No, it doesn't work for months and months. No.
When did he work for your company?
Last year.
Your Honor, I see that the wage garnishment was filed. Looks like October 4th, 21. We sent a failure to disclose letter in November. No response. We entered a default against the garnishee defendant last November. No response.
The red flags start waving. The defendant openly admits he doesn't understand what's going on. Now, honesty might sound refreshing, but in a courtroom, it can be devastating. Saying, "I don't really know," isn't a defense. It's practically an invitation for the other side to steamroll right over you. The judge is patient, breaking things down like a teacher explaining to a student, but make no mistake, this isn't a classroom. Every word matters. The court isn't here to educate you on your obligations. They expect you to come prepared, or at the very least, to have legal counsel who
originally filed. We wouldn't be here today, and if he's not a lawyer, perhaps he should talk with one, but we've had to do a lot of extra steps that would have been helped by filing the garnishment when he was required to.
Well, when the request ultimately is for a $25,000 judgment against Lex Logistics, I think it would be probably appropriate for the court, especially if it sounds like Mr. Falelo didn't work there all that long, that Mr. Leahy have the chance to at least talk to a lawyer about this. Mr. Leahy, you have an obligation when it's not, court stuff is definitely not stupid stuff, because it could absolutely have a huge impact on you financially. But that being said, if you don't have to deal with this very often, it would be something that is new.
In 20 years, I had some companies in 20 years, first time when I ever saw something like this. To be honest, I saw that It's not on my name. I said, Lex. I never pay attention. Now, when I got it, the last one, I really look a little bit into it, and I start pretty much look into the meaning of garnish and all that. And then I start calling your court and all that. And I say, hey, what the heck this one has to do with me? And then they start explaining me that I have to show to the court. I have to explain to you that he doesn't work for me and all that. But for me, maybe if somebody called me, explain me more about it. But I didn't even pay attention to the sum, to nothing. Once I didn't see my name, I get 100 stuff in my mail for a company. To be honest, if it's nothing, I know.
Turning point. The plaintiff lays out the timeline with receipts, literally. They sent letters. They sent reminders. They filed a default when nothing came back. Every single step shows that Lex Logistics had plenty of chances to respond and simply didn't. Courts hate silence. It signals disrespect to the process, and judges don't reward that. It's not just paperwork. Every ignored letter stacks the deck higher against you. And now, instead of a simple response months ago, we're talking about a potential $25,000 judgment. That's
for your failure to answer this garnishment back last year. So I'm willing to discuss these things, but you need to talk to a lawyer about this, because right now, Mr. Butler is looking to get a $25,000 judgment against your company. $25,000 judgment against your company. I would think at that point in time, it might make sense to talk to a lawyer. I can't tell you what to do. I can't give you advice. In my position, if I give you advice, then it looks like I'm showing you favoritism over the other side. I can't do that. And so, Mr. Leahy, I'm sorry that you haven't had to deal with this in 20 years. Thank goodness you haven't. But you're having to deal with it now. So I'm going to adjourn this 30 days. You might not have to hire an attorney, but you can at least talk to an attorney. So use that time. I will tell you.
Okay, but what do I have to do if the only thing what I can tell you, he doesn't work for me and all that? Even if I talk to a lawyer, what can I do in this case? Because I don't have nothing to do to this person, and I don't have no idea.
Leans in here. He's giving the defendant a reality check. This isn't stupid stuff. This is serious business. Court orders aren't suggestions. They're obligations. And what's wild is that the judge isn't being hostile. He's being generous. He's literally advising the business owner to seek professional help before this spirals any further. Judges don't always give you that lifeline. Yet instead of seizing the opportunity, the defendant keeps circling back to excuses about being unfamiliar with the process. It's almost painful.
Where they notified you, the other side, that's basically said, hey, if you're paying this guy some money, a portion of it has to come to us. And you didn't answer that. And that's a problem. And so that's right now, he's not working for you. That's fine. Then you don't owe them like any monies going forward. But there was a period of time where he was working for you. You need to talk to a lawyer about what your obligations are at this point when it comes to Zeal Credit Union.
Okay, and what we can do right now, because I cannot go back and forth. Even right now, I had to stop work.
The smoking gun moment. The defendant admits he didn't bother opening court documents because his personal name wasn't on them. But here's the key detail. The business name was. That means full responsibility. In law, businesses are legal entities with obligations separate from the individual. Ignoring it because it wasn't his name is like ignoring a fire alarm because it wasn't in your apartment. It still matters. By brushing off the letter, he wasn't just careless. He left the door wide open for a financial disaster that...
Okay, but what do I have to do in this case? Okay, what do you want from me now? Okay, this guy doesn't work for me. What do you want from me?
Mr. Leahy, you need to stop interrupting the court. That's what needs to happen first and foremost. Stop interrupting me. All right? So I don't have to... Frankly, right now, you have no good answer for this. And the court could simply grant his motion for default, and then your company would have a $25,000 judgment against it. Why? Because you weren't willing to take a couple minutes, an hour. You say it's taken an hour versus 25,000. I can't understand that conceptually, sir, why you wouldn't want to do that.
This is only in this country can happen for me to own to somebody else some money, and I have to deal with this. You're telling me that it's my fault that I...
There was a time when this employee did work for the company, and at that point, the business had obligations under the law. That window of responsibility doesn't vanish just because the worker later left. The law doesn't forget, and neither does the plaintiff's attorney. This is where so many business owners slip up. They think if a situation changes later, it erases the past. It doesn't. Courts will always circle back to whether you acted properly at the moment the law required you to. And here,
if you're a business person, then you are held to the same standard as any other business person running a business in this state, in this country. And that is, if you get a request of this nature, you're to respond to it. And you didn't. And so I'm giving you a chance here to talk to a lawyer and see what your options are. Now, you say you don't know anything about this. There are so many lawyers who do. And you say, I don't even know what to do or what to say. If you hand these documents to a lawyer, they will know what to do. So I'm adjourning it 30 days. If you want to come back here and say, I don't know what's going on, I don't really understand, and I've given you 30 days to go find out, then I'm not going to have a lot of patience for you, Mr. Leahy. But I'm giving you 30 days to have a conversation that probably will take less than an hour.
Tell him to send me again the paperwork, because I don't have the paperwork no more. I just made a screenshot for this court date. Tell him to send me another copy of those. I'll look into it with the lawyer, and that's it.
I would say talk to the lawyer about that. He or she can call Mr. Butler for any documentations that are any paperwork that's outstanding. I'm sure you have Mr. Butler's phone number. If you contact, if you give your lawyer, Mr.
No,
Butler's
I don't have nothing. I just made the screenshot for my meeting ID, and that's it. I don't have nothing, to be honest.
We said, how did you know about today?
Because I made a picture from that letter to the meeting ID, and that's it.
The meeting ID has the notice has Mr. Butler's the other attorney's name and number on it.
I called him at that time when I call your court to look into this, and I throw the paper away.
Jaw-dropping. The judge is visibly frustrated, yet still grants a rare 30-day extension. Think about that. A $25,000 default judgment could have been dropped right then and there, and instead, the judge hits pause, giving him one last chance to fix things. But instead of relief, the business owner doubles down, complaining about the system and repeating that it's not fair. Fair or not, the law is the law, and the judge spells it out. One more misstep, and that hammer is coming down. It's a lifeline, but also a final warning.